This is Michael Popok, and by the looks of things, it's time for Legal AF After Dark. What was going on during the United States Supreme Court oral argument on whether Donald Trump or any former president has immunity for criminal conduct? What were the 5 or 6 right-wing justices doing? Why were they throwing away the facts of the case and of the indictment and trying to operate in the world of hypothetical? What do we think they're going to do when they finally rule by June? And how does that impact the trial of Donald Trump? Want to know more? Interested by that? Tune into Legal AF. Here's a clip.
Let's talk about these oral arguments before the United States Supreme Court. Look, as far as I always knew, this is a country of we the people. This is a country where no one is above the law. This is a democracy. This was a constitution, a revolution that was fought before that as a reaction to the very concept of absolute immunity. Absolute immunity existed. It was called kings and authoritarians and despots. That's what America was, a reaction against that. So we created a government by the people for the people. That's what we did. So these concepts shouldn't be, to me, overcomplicated or confusing. And if they are, it's because people with agendas are trying to create, complicated issues to justify a dictator, to justify an authoritarian. It's not lost on me, Michael Popok, that just recently the Supreme Court found that President Biden did not have the authority to forgive student loan debt, that was not within the executive power, that the executive power was overreaching by forgiving student loans. That's what the right-wing Supreme Court held. On the other hand, the Supreme Court appears to be seriously contemplating the fact that while President Biden can't forgive student loan debt, Donald Trump can launch coups and kill political opponents. Donald Trump can submit fake electors. Donald Trump can sell nuclear codes. It doesn't make any sense. It's freaking outrageous. And every single person, regardless of what political party, should be outraged about that, provided you care about democracy and a government by we the people. There's no one who should be above the law. Not President Biden, not Donald Trump, not Obama, not any future president. That should never exist. If the president commits a crime, they should be prosecuted. And why in our history has that not happened before? Well, the one time it came close with Nixon, there was a pardon. Why was there a pardon? Because it was widely understood that if the president committed a crime, you could be criminally prosecuted. Why else would there be a pardon? But other than that, we hadn't had a situation like this. Donald Trump tried to overthrow the results of a free and fair election. It happened in plain view. Yes, the January 6th committee laid it out, but we all saw it. It's not a disputed fact what went down, no matter how many times MAGA Republicans want to talk about how it is peaceful and patriotic. That's not what took place on January 6th. And let me just share with you just a few video clips, and then Popok, I'll let you give your analysis. But let me just set the stage like this. And first, let me set the stage by showing you an interview that Bill Barr just gave with CNN, where he laughs and jokes that, Donald Trump did tell me he wants to execute people, but that's just Trump being Trump. Here, let's play that clip first.
But Alyssa Farah Griffin, who was Trump's communications director, posted yesterday and said that you were present at a moment when Trump suggested executing the person who leaked information that he went to the White House bunker when those George Floyd protests were happening outside the White House. Do you remember that?
I remember him being very mad about that. I actually don't remember him saying executing, but I wouldn't dispute it. It doesn't sound. The president would lose his temper and say things like that. I doubt he would have actually carried it out.
But he would say that on other occasions. You said
the president. The president had I think people sometimes took him too literally, and he would say things like similar to that in occasions to blow off steam. But I wouldn't take him literally every time he did it.
Why not?
Because at the end of the day, it wouldn't be carried out and you could talk sense.
But just because it's not carried out and you could talk sense into him doesn't that still mean that the threat is there?
You know, and then there was January 6th. I mean, that person was the former attorney general. And when you make a statement like that, how dare you ever say you care about law and order again? I'm not going to show you all of these clips of Donald Trump's lawyer, John Sauer, making, the arguments. I'll show you one example of it so you get a flavor for it. But let me be very clear what he said. He argued that assassinating a political opponent would be an official act. You'd receive immunity. Staging a coup with the military would be an official act. You would get immunity. Selling nuclear secrets, Trump's lawyer said, if structured as an official act, that's the exact language, if structured as an official act, you'd be able to get immunity. Fraudulent slates of electors. Is it plausible that you can submit fraudulent slates of electors? You know what? Let me show you that clip. I was going to do the one with assassination, but y'all have heard that one before. Let me show you the one where Justice Sotomayor asks Trump's lawyer, what about creating fraudulent slates of electors? Do you get immunity for that? And Trump's lawyer says, absolutely. Absolutely was the answer. And then he talks about some tortured view of history with President Grant, and he doesn't even answer the question. It's a bunch of word salad. And I'm like, and Justice Sotomayor's like, you're saying fraudulent. You can submit fraud electors to overthrow an election? Here, play this clip.
Apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cite in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to...
What are you talking about? What are you talking about? I'll throw it to you, Popok. The very fact that this argument is taking place in the United States Supreme Court brings so much shame to our country. And you and I have such a big international audience. I always get emails from people in Australia and the UK and Germany and across the world, South America. We get emails every day from people. They're looking at this and saying, what? Huh? Seriously? Popok, what'd you make of it?
Well, I think I agree with Lawrence Tribe that the stain on the Supreme Court, based on where I think this ruling is going, and I'll give you my view of where I think this ruling is going to be worse than it was on than Bush versus Gore, and I can kind of break that down for you. And I've given the decoder ring in the midweek edition. When you hear the right wing conservatives, Kavanaugh, Gorsuch, and Alito, and even Roberts, using the following phrase or a version of it, let's forget the facts of the case. Let's talk about it in the abstract. I don't care about the indictment against Donald Trump. I'm worried about the future and legacy. When you hear those judges say that, especially knowing that each of them was either in the Department of Justice or in the White House at the time that this concept of the unitary executive branch or the supremacy of the presidency held sway, and that is obviously something that Kavanaugh, who's always been referred to as a political hack, Gorsuch and Alito and Thomas believe that not only is the president the sole occupant of one of the branches of government, but the occupant of that office. It always happens to be a Republican whenever they make pronouncements like this. It's never a Democrat who's in office. Bush versus Gore, they side with Gore. Trump v. US, they're going to side with Trump. Even though they're saying, we don't care about the facts of this case. Well, first of all, you have to care about the facts of the case. That's what Sotomayor, when you played her clip, is trying to bring this back and ground it in the live case or controversy that is before the court, because otherwise, what are we doing here? This isn't, as I joked before, not even joked, as I said before, this isn't ChatGPT. You just plug in facts and ask for a law of the land to be cranked out. This is supposed to be based on the indictment. They never mentioned the indictment on the right wing of this court during the oral argument. They rarely mentioned the issue that was supposed to be on appeal, which was, as a former president, enjoy immunity for official conduct. Although Roberts got the lawyer for the Department of Justice sort of wrapped around his axle on the issue of whether, as I said before, the DC Court of Appeals got it right or wrong on the fundamental issue that even in official acts, there can be criminality that needs to be prosecuted. Roberts doesn't like that. He said it out loud. We don't like that. And we're going to have to make a change there because I don't like that tautology of it's a crime because it's a crime. And we're going to figure it out. So this is where I think it goes after all of this thought experiment about assassinations and coups and fake electors all being official conduct. And to paraphrase Justice Ketanji Brown Jackson, who continues to impress me as becoming the intellectual heavyweight on that court in only her second year. And she said, why are we even talking about trying to divide things between official conduct and private conduct? Why does it matter if what we're talking about are moral crimes that are so obvious that it automatically takes it out of official conduct? And why are we talking about immunity in those terms? Totally agree with her. Here's how I think this comes down, based on 5 or 6 votes of the right wing, as I think Amy Coney Barrett gets sucked over to the right, although she seemed to dance in the middle during the oral argument. I think they're going to send it back down to either the DC Court of Appeals or likely Chutkin to figure out and look at the indictment. Because now they're going to look at the indictment. They didn't look at it at all, care about it during the hypotheticals on their oral argument answers, questions and answers. But now they're going to tell them, go through the indictment, the overt acts and the acts that underlie each of the counts, the 4 counts against Donald Trump, and divide that world into private for personal gain on one end and official core presidential conduct on the other end, and then hybrid things that started as official conduct or within official conduct and became private, like bribery of an ambassador appointment, as some of the justices talked about. And then they're going to rule that if it falls into the bucket of official conduct, no matter that it moved into criminality, or as Ketanji Brown Jackson said, what I'm worried about is not that the making something criminal that even a president at the time can be held accountable to will have a chilling effect on that president's exercise of his powers. I'm worried that without it, the White House becomes the seat of criminality. That's Ketanji Brown Jackson, and she got it dead right. So what they're going to say is if it's official conduct, absolute immunity. That's going to be the new law of the land coming out of this 5-4, 6-3 ruling. If it's private, and many of the things that are in there, campaigner in chief, trying to cling to power, that's not an Article 2 thing. That's a Donald Trump doesn't want to leave office thing. And that could be categorized as private. That's not going to get immunity. And then you got this world of the hybrid with whatever guidance that's going to come out of this written decision written by Roberts or Alito or one of them, that's going to say, if it's a hybrid, then on a case-by-case basis, you have to do this analysis. And maybe there's absolute immunity and maybe there isn't. And all the great things we heard from Sotomayor, Kagan, and Ketanji Brown Jackson are going to be vigorous dissents that are going, I am making this prediction. and hopefully we'll still be on the air 20 years from now, as history looks back on the stain of this court and what the Roberts Court did, in much the way Karamatsu, the decision to intern Japanese Americans, was seen as a stain on the court. Decisions about education and Black Americans was seen as a stain on the court until those things were fixed, and other things related to slavery. This is going to be a stain on the court that's going to have to be fixed, and they're going to go back to the dissents of, I hope each of them writes one, and they're going to say those people got it right, and history is going to judge the majority opinion as being, you're letting a president commit a coup or assassinate someone in the interest of official conduct, and you gave that person immunity. As you said, what kind of world are we now in?
And Popok, there's always been this doctrine that they teach you in law school, and how the United States Supreme Court, one of their core doctrines is constitutional avoidance, right? Where they can avoid making sweeping statements that could have massive detrimental constitutional impact. That's what they'll do. So why would they go in the direction that you say, which I agree is where they're likely going to go, to allow authoritarians and dictators to essentially take root in the White House, versus just addressing the conduct here, right? Like, only Justice Sotomayor in the clip that we showed, that's why I wanted to play that one. That may have been one of the only times that her and maybe Justice Ketanji Brown Jackson were actually talking about this case. This case. What occurred on January 6th? What occurred here? Fake elector slates. What Trump did to try to overthrow our democracy, which, by the way, Supreme Court, would have then led to the overthrowing of likely you as well, and would have just led to a dictator. Why weren't we talking about the case? Same thing when it came to the disqualification case that went before the Supreme Court. They refused to talk about the insurrection. They refused to even talk about the conduct that took place. That why we're even having this discussion is not some hypothetical law school academic exercise. It's a real thing that occurred to try to overthrow our democracy. It exists. Your job as a judge is to judge the thing that happened. Are you cool with it? Are you not cool with it? That, to me, is a very basic principle.
That's why you're in trouble, and I wanted our audience to know it. When you're listening, because I want them to be, and you do too, and so does everybody else on our network, educated consumers of this information. We don't just host the live stream for oral arguments in the United States Supreme Court for no good reason, and to service our community, but we also do it in our analysis to let you know in advance. And I'm just telling you right now, this is easy. This is the tell of the United States Supreme Court and the right wing. When they start talking about, we don't want to talk about the facts of the case. We don't want to get embroiled in the facts. I've heard them say it during the religion, separation of church and state arguments. And when you hear that, run as fast as you can, because the next thing, and it wasn't just one this time, it was Alito. Let's talk about it in the hypothetical because we don't want to get bogged down in the facts. Kavanaugh, same thing. Gorsuch, same thing. Roberts, in his own way, same thing. Look out. Here comes the judicial activism that conservatives, look at you and I, you defending conservatism, not but just as a principle, because they're not. This isn't conservative. This is judicial activism, for which they attack Democratic appointed judges when all they're doing is they came onto that oral argument and they wanted to reverse engineer with a position that they wanted to take. They knew they were going to take it, and they wanted to throw all the distracting facts out of the way. And the problem the advocate for the Department of Justice had, who I thought did an okay job. He came in, poor guy. He came in wanting to debate the lower court decision as it related to the appellate question that was framed for the appeal based on the indictment in front of him. But what he ran into was the headwinds and the turbulence of right-wing justices that wanted to make new law It's always for the Republican president for some reason. And just one last thing on that. So we want to call them out, to say we don't care about this president. We're making a statement for the future, the history, and the legacy. No, you're not. Yes, you are, because we're going to be stuck with this terrible, terrible decision. And if Ketanji Brown Jackson is right, and I think she is, can you imagine what Trump 2.0 without this threat that he could be found in criminal conduct for something that he does in office, what he'll do, or the worse, what the next occupant of the office does with this now as the precedent? At least Nixon, knowing that he could be prosecuted, he did really bad things. But could you imagine what he would have done had he thought that he'd have no criminal liability? And it's not even dystopia. It's not even apocalyptic, what Ketanji Brown Jackson said. Of everybody that said something on that panel, that was the one that resonated most with me. We're going to convert the White House into the seat of criminality when it's occupied by the very wrong person like Donald Trump.
And what I think needs to happen in response is, one, pro-democracy voting, but two, there's got to be legislation that gets passed that has to affirmatively say every single law that exists here, the president shall be held criminally responsible, to then which I guess if you play that out in the hypothetical, then that gets challenged as a separation of powers constitutional challenge. But, in any event, if you look at these rulings, and again, just take, the same thing with Dobbs, where they didn't want to address the facts even before it, and they expanded it. The Dobbs decision, Popok, was not the question before the court, was not, do you overthrow Roe v. Wade? It was whether this law in Mississippi was valid or not valid. And then they used that to overthrow Roe v. Wade, to overthrow super precedent, and then they completely demolished massive precedent by answering a different question than the one that was before it. It goes against everything that you were taught at Duke Law School, everything that I was taught at Georgetown, everything that we, grew up learning about the law. You have these people in the Supreme Court, the right-wing justices, and they've been working to create this for decades and decades and decades. And they've been, using the gaslighting terms of, we have to stop the activists, we have to stop that. Then they get on, and what do? They're the most activists. They torture and destroy the Constitution. And ultimately, they're creating the downfall of themselves, too, as the Supreme Court. It's so naive. It's so dystopian, because if you're going to give the authority to a dictator, the first thing they're going to do is get rid of you. It's really horrific.
Make one point before we move on to the last segment, because I always hate to end on a dour note, and I want to tie it to what you've said and I've said throughout this podcast and throughout Legal AF. What you can do about it. Look, 6-3 right now. The super precedent that you talked about that used to be so enshrined in constitutional analysis, that a case that had been affirmed over and over and over again, like Roe versus Wade and the underpinnings of it, would not be easily disturbed. That's gone out the window. What that means for me is, if Biden gets back in, which we're working hard to have that happen, and the next president is also Democratic, there could easily be 2 vacancies. Trump got 3. There could easily be 2 vacancies. If there's 2 vacancies, we won't get into how vacancies happen, but if there are 2 vacancies, it becomes a 5-4 court the other way. And a 5-4 court the other way could revisit Dobbs and revisit all of this crazy stuff that's going on right now and say, what super precedent? We just did it, 4 years ago, 3 years ago. We need to fix it. And they could fix it, because what the Republicans have done on that panel, on that court, is signaled that precedent and super precedent and stare decisis don't matter. So if they don't matter, then when the Democrats get back into power, and if it goes 5-4 the other way, with just 2 votes going the other way, then we can fix this stain and the scourge on the history of, and we don't have to wait 10, 15, 20, 30 years. I'm just going to leave that out there. That means voting matters. That means November 5th matters, down ballot and otherwise. And that means getting the right person into the occupancy of the Oval Office really matters. I have left my friends who were sort of apolitical or neutral in the past. I've said, I don't care if you care about anything else, but you have to put the right person in to pick the United States Supreme Court, or you're not going to like the result. I said that 10 years ago. I said that 5 years ago. And look at the landscape we're in right now. Welcome back. We do that show, a podcast we call Legal AF, every Wednesday and Saturday at 8 p.m. Eastern Time, only on the MeidasTouch Network. Want to find out why we call it Legal AF? Join us. We'll tell you, Wednesdays and Saturdays at 8 p.m. We sit at the intersection of law and politics so that you don't have to, and we bring you our best estimate, guess, analysis, opinions based on years of experience in these very types of courtrooms and courthouses. You like lawyers talking about things where they know what they're talking about? Then you'll love Legal AF. And then you can take that particular clip, if you've already seen the show, send it off to your friends, family, people in your life, and say, hey, that's Legal AF. Maybe they'll make that 10-minute investment and join our hour and 15 or 20-minute show. If you don't know what I'm talking about, that was a teaser. That was Legal AF. Join us on Wednesdays and Saturdays, 8 p.m. Eastern Time, right here on the MeidasTouch YouTube channel. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.